Call 1. Did City High's termination of Page without a hearing violate procedural due process in the 14th Amendment? Call 2 is about the state and Attorney General's motion. And I look above and it says State X and the Attorney General have moved to dismiss the suit based on standing and the 11th Amendment. So call 1 is restricted to procedural due process. Call 2 is restricted to standing and the 11th Amendment. Okay, what do we have here? State X has a valid contract with public school teachers, providing a fixed salary schedule. State X recently passed legislation to address its failing public schools. Now, when a school falls below established standards, each teacher at that school has 10% of his or her salary withheld each pay period for a maximum of 2 years.
Well, there's a contracts clause problem here, but they told us not to write about it. They told us to just write about the 3 issues.
The withholding ends and the money is returned with interest upon the completion of a 10-hour certification program or termination of employment. City High is a public school in State X where salary withholding has begun. Bob has been a teacher at City High for the past 3 years. Paige is a highly regarded probationary teacher at City High. A probationary teacher may be terminated for any reason upon written notice within the first year of employment. So that's employment at will, in essence, for the first year. Bob and Paige have been outspoken opponents of the State X law and its application to City High, appearing at various community and school board meetings throughout the school year.
So it looks like they're expressing their free speech rights against the State X law.
Shortly before the end of Paige's first year of employment, City High served her with written notice terminating employment and refunded the money withheld with interest.
All right, so they want you to say no harm, no foul.
Except it's more complicated than that. It looks very much as if, and her argument will be, that she was terminated for exercising her free speech rights.
It says, did City High's termination of Paige without a hearing violate the procedural due process guarantee under the 14th Amendment? So we're talking only about Paige. She's the probationary teacher. Now, how does it work? Basically, when you get a question like this, you want to talk through the law as you analyze the facts. It's about procedural due process, and procedural due process, we must have a liberty or property right. And if we have a liberty or property right, where the state is depriving a client or a plaintiff of a liberty or property right, then there's a 3-part test that we would apply to see if the plaintiff's due process rights are being violated. So the first thing that we have to do, if you really want, I think if you wanted to excel on this question, you want to try to come up with a property or liberty interest. So our questions here would be, what would be some property or liberty interests that we might have here?
So liberty rights include any kind of loss of freedom. Doesn't look like that's exactly it here. The right to contract. She had a valid written contract guaranteeing her a certain level of salary per month, and they interfered with that.
Okay, it's colorable and you should talk about it, or that's one theory you could or could have used. And I think if you found that one and you ran with it, I think you'd be okay. If you, in either case, you might have wanted to try to see if you can find something else.
So under property right, what most of us think of usually right off the bat is that you have some sort of an entitlement and the state takes it away from you. Well, we could make that argument for Bob because he's been there for 3 years and he's entitled to continue his employment. But Bob isn't the one they terminated. It's Paige, and she, in essence, had employment at will. Property rights include continued attendance at a public school, they include welfare benefits, but they also include government employment. She worked as a public school teacher, so in essence, she was an employee of the state.
See, it looks like you don't have a leg to stand on. It's written down. It's employment at will. Well, maybe whoever wrote that down is violating the law. And if we're going to be Page's advocate here, which is I think what they wanted you to do, you would have to try to make some colorable argument for a property or liberty interest.
I would be making the argument that taking away 10% of her pay per month was in itself a deprivation. Not just losing the job at the end of it, but losing that 10% all along.
And then finally, we have some good facts here. Number one, she was speaking out against the law, so she's exercising her First Amendment rights. So now we have another protected right, another liberty interest, your First Amendment rights. And we also have the fact that she was a highly regarded probationary teacher, meaning that she was competent. And so when they fired her, they must have had some ulterior motive. So therefore, you see how we start championing the rights of Page, and all of a sudden we find that Page has a lot of colorable arguments that she can make in order to say her procedural due process rights have been violated. We've made an argument that she had a contract, or her right to contract is a liberty interest, and we're making an argument for a property right. And that's how we get to first base with this. And of course, even if you didn't find a property right, you would want to go on to the three-part test. And one of the things we look at in that three-part test is the importance of the interest to the individual. And of course, you would want to make this consistent with your the right that you're invoking. Are you saying that she had a right to continue her employment there because it's government employment, so then she was fired? Or are you talking about her right to contract? I think if you say she was fired, that's a little bit more powerful. She loses her whole job. How important is that job to her?
That's her livelihood. But I would argue that this violation of her right to engage in this contract is perhaps just as important if you think about it. If you think about making a living wage as a teacher, and now all of a sudden a government entity says, you know, because your school isn't performing well, we're going to take away 10% of your pay. That's a big bite. And most of us don't have a whole lot of disposable income. The essence of doing a procedural due process analysis is first you have to establish that there was some sort of a right that was violated. And we've talked about that at length. Then, assuming you have that, a liberty right or a property right that ensures you procedural due process protections, now we go through a three-part test to determine what procedures the government would have to have in place in order to do what they did, in order to justify the way they did this deprivation. And Dr. Saccuzzo just talked through the importance of the interest to the individual. The second part of the test is the importance to the government, which usually is fiscal efficacy, efficiency. What's the cost to them? They have basically said if a school is underperforming, we're not going to try to identify which teachers are bad at teaching. We're just going to penalize everybody by docking them 10% because that's the easiest thing to do. So, you know, that's a weak part for the government. The third part of the test is the ability of additional procedures to increase the accuracy of the fact finding. And what does that mean?
Well, okay, that means that you're required, the procedural due process clause requires adequate notice and opportunity to be heard. And the question is, well, what's adequate notice here? And what's opportunity to be heard? And basically, Page has no notice and no opportunity to be heard. And so can we have another procedure that might make this more fair and more accurate? And what we have here, what they're asking, without a hearing. And so we would just basically focus, would a hearing have made this process more accurate and fair? And I'd say absolutely. If they would have had a hearing on the matter, they would have found out that she was competent, and they would find out that there was an ulterior motive for firing her. And so therefore a hearing would certainly be much better notice and opportunity to be heard. And so therefore I think the answer is yes, they have violated Page's due process rights.
So Bob and Page filed suit against State X, the Attorney General of State X, and the City High in federal court. They asked for damages and injunctive relief. State X and the Attorney General have moved to dismiss based on standing in the 11th Amendment. Call 2 is about the state and the Attorney General's motion. We have to talk about standing, and we have to talk about 11th Amendment.
Okay, so we take them one at a time. Standing. To have standing, you need injury in fact, causation, redressability. It seems like I don't know too many law students who can't do the standing analysis. Just about every law student I know can do a good standing analysis. Just stick to your facts. Injury in fact. Bob, what's his injury in fact? He's basically having 10% of his salary withheld, and maybe for another year. So not only has it had happened to him, he's looking to see it happen again. And that's his injury in fact. And causation, this is caused by the state or the
State
law.
X law, yeah.
And so, and redressability, he wants that law tossed out. So that's pretty easy. And what about Page? We've already discussed the injury in fact. I think what they were trying to do is hook you into saying, well, Page hasn't suffered any injury. And I don't think that's the case here. I think we've talked a lot about, losing her job as being quite an injury. And so I don't care that it's employment at will. She lost her job. So she suffered injury in fact. And causation, again, redressability. It's a simple matter. You just focus your facts. And then 11th Amendment. And if they had said, even public school, what's the 11th Amendment say?
It says that an individual, a citizen, cannot sue a state in federal court without its consent. The original amendment said you couldn't sue another state, but the Supreme Court expanded that and said it couldn't have meant that you can sue your own state. Your own state is included. So you can't sue a state without its consent, but then there's a list of exceptions. And of course, they're testing exceptions.
Right, and state officers is the exception. And Bob and Page they're asking for injunctive relief here. That's part of their remedy. And part of that relief would be an action in federal court to enjoin illegal conduct by a state actor. Is one of the exceptions to the 11th Amendment. That's what's going on here. And we would just cite that exception, discuss our facts, and I think that would handle this one.